viewing courtroom, so let's go ahead and do that. So we'll be waiting a few minutes then while we are getting the viewing courtroom situated.
So, okay, keep the way clear.
You can let me know when the folks are ready.
Okay, we'll give you a knock.
Super.
Are we waiting for other folks?
For this portion, I believe we're just going to hear from attorneys for two of the victim or victim families.
Is that here?
Yes.
We're good. Everybody's ready. All right.
Good afternoon. May be seated. We are on the record and we are outside the presence of Mr. Christian. Earlier today, the court ruled that he forfeited his right to be present for the victim's statements based on his outburst during his sister's statement. And he is now not present. He was not here for testimony of two of our folks. Well, several of our folks. Ms. Hudson, Ms. Allen, and Mr. Burt Best, and Mr. Eric Best. So I understand that there is a request from the victims that he be present to hear their statements. And so who wants to speak to that?
As I've asked both Ms. Olson and Ms. Brewer. Ms. Olson represents the family of Collision Meche, and Ms. Brewer represents Michael Fletcher. And they're both here, and I think one or both may have some things to say on this issue.
Okay, and you guys can come and we are exercising physical distancing, so maybe Mr. Howell, you can be seated while they come to the council table.
Yes.
And you can state your name and bar number.
Thank you, Your Honor. Aaron Olson, bar number 934776. I represent the family of Felicia Meche. Your Honor, as you know, due to physical distancing requirements, the victims' families have been in a different courtroom. So we were watching things on the screen when Mr. Christian's outburst caused you to understandably remove him from the courtroom. But when the court said that he would not be brought back, there was a palpable reaction in the room. And I think it was a very emotional reaction, but the reaction was based on the fact that part of the remarks they've been preparing have been intended for his ears. They are not the sort of remarks that are going to inspire the reaction that occurred previously. They are remarks about their loved one and the loss to them of their loved one. And so we would ask that he be brought back, understanding that the court has concerns about his behavior. Our request is made under the constitutional provisions of Article 1, Section 42, which do not specifically say that the victim has the right to have the defendant present, but they do in Article 1, Section 42, 1A. Say that the victim's right to be present at and upon specific request to be informed of critical stage proceedings held in open court when the defendant will be present. And one of those critical stage proceedings is a sentencing proceeding. That is to give the victims the rights to be here during important proceedings, of which this is one. And we understandably don't have a citation for the proposition that when a defendant has forfeited his right to be present, the court should order him to be returned in shackles if necessary in order to have to listen. Mr. Christian behaved reasonably well throughout the trial. We would like to think that hearing the heartfelt, emotional statements by victims about the losses to them of their family members would not inspire the sort of reaction that he manifested earlier. And based on the premise that the rights of the crime victim are to be balanced against the rights of criminal defendants, we would ask the court to bring him back down to listen to the remaining victim impact statements. My clients who are intending to give a statement today are Vajra, Felicia's sister, who is personally present with her husband. Felicia's mother, Asha Deliverance, is planning to give one remotely. Felicia's brother, Christopher Lejeune, is planning to give one remotely. Ati Messiah, one of Felicia's other sisters, is planning to give one remotely. And Papa Chris, or Felicia's father, is planning to have one read by Asha. They would like the defendant to hear what they have to say, and we would ask that you order it.
What would be, one question I don't know, and one thing, we're doing a lot of technological aspects in this hearing, this proceeding that we've never done before, necessitated by COVID-19 physical distancing requirement. One of which is that we have video connection to other courtrooms where people are viewing proceedings, so as to comply with our Article 1, Section 10 provision for open courts. One option that we have, we've used all the video equipment that we have for that purpose, so we don't have video equipment. Anyway, we're kind of juggling video equipment, but one option we do have is to clear one of those courtrooms, place Mr. Christian in that courtroom. I don't know, I would imagine that one of the things that the people providing victim impact statement have prepared for is to face him directly. It's a different process to speak to an amorphous person who may or may not be listening in a different room. I don't know whether the video would be able to show him to either the people up here. I think of the people appearing in person, they're only going to be in the courtroom. They're not going to be able to see into any other courtroom. The view is only into this courtroom.
We can set it up, perhaps, to view the courtroom user.
I understand the court has that in the works, and certainly that's better than the alternative of not having him audibly present or visibly present at all, which, as I understood it, was what he was planning to do. But it's certainly not the same as being in an open courtroom with him present and having him listen to them.
Ms. Brewer, did you want to speak?
Yes, Your Honor. My name is Rosemary Brewer, bar number 110093. I represent Michael Fletcher, who's the named victim in this case. Mr. Fletcher prepared a statement today, assuming that he would give it to the court, and that Mr. Christian would be in the courtroom at the time he was giving the statement. As the court knows, victims do have a right to be heard. They also have a constitutional right to have a meaningful role in the criminal justice process. I would argue that for a victim making a statement about how this crime affected them, it is not truly meaningful if they cannot address the person who caused the harm in the first place. Mr. Fletcher would ask that Mr. Christian be returned to the courtroom while he gives the statement.
think the main concern that the court has is he's forfeited his right, so I'm not balancing his right versus the victim's right, but what I am, I think frankly he's forfeited his right to be absent as well in that regard, but what I am considering is the orderly functioning of the court and for the court to go do its business. So as to that, Mr. Scholl, do you have any remarks?
Judge, having met with Mr. Christian during lunch, we have no position on any of this officially for the record. I will say that if he is going to be brought back to this courtroom or a different courtroom, I would ask that he be allowed to read his own allocution statement. In other words, if he's going to attend, I think he has to attend and take care of that himself. If he's going to remain in jail the whole time, then he's asked me to read that statement for him. So his position is, I think he has no position. My position is I'm happy to have him here or not, whatever the court decides to do. But if he's going to be brought back, I'd like for him to have the opportunity to read this, and that may be difficult if he's in another courtroom.
What I would like to do is to determine whether we can, and we may not be able to do this, and it's going to take us a few minutes to do this, to figure it out. But is for us to figure out whether he can be in one of those courtrooms. I understand Mr. Smith would be there with him, and that the person who is speaking either by video or in person would be able to see him in full face on that screen.
So we are in the process of setting that up in 220, the former civil commitment area, where he would be able to see the courtroom and the TV would show him what was going on in the courtroom. 448 is currently empty and available, but he would only be able to see what's going on in the courtroom.
Okay, so but in 22A it would be
220, I believe.
and the person appearing by video would be able to see him?
Yes.
Yeah, wow, okay.
That's, so, wait. That I have to check on, I'm sorry. We would be able, yeah. So,
And I think maybe 448 is where he would have to be in order for that to happen. And I don't know if we can have one video show him full screen and then another video show the speaker full screen.
right.
And they basically two videos watching each other.
Let me see if we can get, David Broad, the person setting this up. If we can get a hold of him, he can give us those answers. Let me set out and do that.
Okay, thank you. Yeah, so we're gonna see whether that's a possibility. My preference to maintain orderly functioning of our court hearing today is for him to be in 448, but I want that to be able to be a meaningful experience for the victims. And so I think that the way that we could make that a meaningful experience is for, as I was saying, for one video monitor to have him full screen, the other video monitor to have the speaker full screen, and those video monitors be able to watch each other. And this is probably one of the first times the Court of Appeals or the Supreme Court are going to consider this issue on appeal. So we'll take a few minutes to work that through. Any questions, Sergeant?
No, Judge. From my experience, that has been done before. We did it. We Judge Ryan's courtroom. We've done it before. So
Okay.
there's both of you can interact with each other.
Okay. We'll see if that can work out. Thank you. We're in recess while we're figuring that issue out.
So right now, this TV, your camera is off into courtroom, whatever, but for courtroom, see, I think I can, courtroom 448, I can make a panel, and then, that's the one thing I want to do. We can have two, so. But check this out. That right there was on the screen, that's C3. That's courtroom 328. have,
Once we have
The victim will be on the screen.
right, but
But the victim, if they want to, what we do is we could talk to the Rachna, and the victim, when they're testifying, they could pin his courtroom to their WebEx, so they're looking at that courtroom. See what I'm saying?
I could see in theory it should work. I don't know if that's.
Yeah, because I can only pin one screen to ours here, so I'll pin the victim.
So for the regular person, you could have that screen show it all.
I can, when someone's testifying in person, I'll pin,
The other room, yeah. So that.
or wait, but if I pin the other courtroom,
Oh, then nobody else will be
then,
able to see.
then no one will see.
Yeah, let's do
I think you're right.
You send a message.
I send them a message.
Okay. See if we can
I have a copy. Can you hear us?
Come on, back.
according to the page.
Sage, can you hear us? What did they say?
Says, I'm sure we're aware of if I have live here and still shoot an audio, so we can just speak.
The other thing is that the way that
So what you're suggesting is that people will not be able to see the witness speaking and
kind of the angle of it is catching everything